I'm going to ask, well, what's my ROI? So
Yep.
does IP add value or make my business money? Like,
Absolutely, 1,000% it does. And there's a ton of statistics out there. Just Google, does trademark add value to my company? And you're going to see the articles that are out there on it. And it ranges, for example, when you trademark.
what about copywriting software? What's your thoughts on that?
Nope. Terrible idea. And that's a big misnomer that's out there. Software, people develop code, and you know, I imagine these young folks sitting in garages with computers just programming, and they come up with this great stuff, and they're super smart, and they read online that software can be copyrighted. 100% true, it can be, but it just totally foobars you. When you copyright software, you have to deposit a copy of the source code with the Library of Congress. That is public information. So folks can go in there and get a copy of your source code and then reproduce it. Copyright protects that exact language as you've laid it out in your software code. Every programmer out there knows, and I was a programmer as well, it's very easy to change just a little bit of the code lines and do the exact same thing and get around the copyright. So it's a bad idea all around to copyright software. You're essentially giving your source code away, which is a terrible idea. You get protection that's easy to get around, which makes it a terrible idea, you know, over and over again. So software, unfortunately, bad for copyrights. You have to step up and go to the patent to protect software, and it's a lot more expensive to do that, but that's where you need to be looking.
Right, so if you don't want your competition doing what you're doing, patent now becomes the way to go.
For software, for sure, 100%. Don't ever copyright software. It's just, it's one of the worst things you can do, in my opinion.
Right, and since we were talking lifespans, how long is a patent good for?
Patents are good for 20 years from the filing date, when you first file it. That's a little bit misleading, because when you first file your patent, you don't actually have it. It's called a patent application, and it goes through an examination process that's staged out over, say, 2 or 3 years, and then it issues as an enforceable patent. And you get the rest of that 20-year window as an enforceable patent, but it starts from the time you actually file it, which usually a couple, 2 or 3 years before it actually issues.
Okay, and if I have an invention, as I understand it, I don't want to disclose that until I file the patent. And why is that?
Absolutely, yeah. The U.S. Was one of the few states that allowed you to do that for a number of years. And just not that long ago, we changed our laws to be a first to file country. And so it's literally a race to the patent office now. And so if you don't file for your patent before you publicly disclose it, you're going to give up the bulk of your patent rights. You still have an opportunity to protect your invention here in the U.S., but you're going to forfeit essentially almost all of your patent rights outside.